In this star-studded episode, human rights activist Chief Gani Fahimi, SAN of blessed memory, engages in a long drawn-out argument with other learned silks over the seriousness of the appearance of former heads of states, General Ibrahim Babangida and others, when they are summoned to the commission either as witnesses or respondents. Present at the sittings are counsels for General Ibrahim Babangida, General Yakubu Gowon, and President Shehu Shagari, among others. This episode, I believe, will catch the interest of lawyers and law students, as it is more of an academic exercise when compared to the usual petition segments. If you've learned a thing or two from this episode, don't forget to leave us a comment, give us a thumbs up, share with your friends, and we'll see you in the next video.
Finally, sir, I would like to make 10 propositions. 1. The commission set up under the Tribunal of Inquiries Act, CAR 447, laws of the Federation of Nigeria, is a fact-finding body. 2, that any summons issued by the commission and served on anybody is personal to that person. 3, that the essence of the summons is to command the attendance of that person to the commission to testify under or to testify and or produce documents. 4, that anybody so summoned by the commission becomes a witness of the commission and not that of either the petitioner or anyone against whom or in favor of whom the petition is directed. 5, that the person summoned by the commission must personally appear and can, after appearance, be represented by counsel. 6, that no counsel can be substituted for a person summoned to appear, i.e., the person summoned to appear cannot be represented by proxy. 7, there can be no representation without presence, i.e., a person summoned cannot be legally represented without his personal appearance at the commission. 8, a person who testifies, who refuses to appear after being summoned to appear, commits a contempt of the commission. 9, a counsel who, without satisfactory explanation as to the absence of the person summoned, announces appearance with a view to cross-examining witnesses or attempt to call witnesses, will be committing a contempt of the commission and be acting unprofessionally, whether he's SAN or not. Number 10, to allow a counsel to represent a summoned witness who does not personally appear will amount to allow the witness to benefit from his own wrongdoing, and that will not be even-handed. It will not be justice. It will not be equity, and it will not be morality. That is what this commission should stand for: justice, truth, even-handedness, morality, and sincerity of purpose. May God bless you.
Thank you very much. Who takes the floor?
My Lord, I would start by referring to the petition of the petitioner.
This is for the submissions?
Yes, sir.
So we can look at this?
Yes, my Lord.
All right then.
Yes, my Lord.
We don't have.
Did you say? For service. No, but I have to make use of one.
they want to give us. Yeah, I want to say what the
There is a motion, sir. And there is a submission too, which was filed this morning, is it? This morning, on behalf of my client, General Ibrahim Babangida. Response, I said.
Yes, we have one here, a response of General I.B. Babangida,
Yes,
CFR.
Yes, my lord.
I have a bigger one. Is that the same? This is
No,
bigger.
I think this is different.
The same.
It is the application to dispense with the appearance of Ibrahim Babangida
Oh, I see.
in the form of a motion, my lord.
Oh, well, we are not dealing with this now.
No, I'm not dealing with it.
All right, we are dealing
But
with this.
it will be subsumed in my argument.
All right. All right then.
My lord, I will start by the petition of the petitioner, signed by Ebun Olu Adeboruga, on behalf of Chief Gani Fahimi, now a senior advocate, dated the 30th of July, 1999. Now, I refer first, my lord, to paragraph 3. I just read.
Clerk of court, have you got the petition they filed? Clerk of court, counsel for the commission. Have you got the petition for the, so that we all add idem? Exhibit 1. We have said, we have seen it. It's all right.
Well, you said this thing will wear out with time with you, you know. My lord, may I have...
Have you got the correct one?
No, my lord, may I have the exhibit 1?
Exhibit 1.
Yes, my lord.
Give him exhibit 1, please. Our exhibit 1.
I told you this thing will take time to wear. Thank you very much. Now, my lord, I'll start with...
Who signed that one?
Nemeka Amechina, still dated the 30th of July,
I see.
as the one I used. The same thing.
You are referring us to exhibit 1.
Exhibit 1, my lord. My lord, I'll crave the indulgence of the commission. I don't want my attention to be diverted, because I was quiet when my learned
Please
friend...
let nobody divert his
Yes,
attention.
yes, my lord.
Please.
Paragraph 3. I'll just read a few paragraphs. Few days before his death, Mr. Dele Jiwa was being trailed, investigated, and monitored by senior officers of the military regime of General Ibrahim Badamasi Babangida. Now, I also refer to... It's the same thing. Also to paragraph 4, particulars of infringement. The deceased was presented with a parcel bomb dressed in official conflagration, but which connected the military regime of General Ibrahim Babangida. My Lord, the emphasis I'm making here is the regime of General Ibrahim Babangida. I'll also refer to the second paragraph after 4. Second paragraph. The presentation of the parcel bomb which killed the deceased was a cruel, wicked, invidious, and satanic act cleverly hatched and executed by the military regime of General Ibrahim Babangida. I also refer, my Lord, to paragraph 7. Paragraph 6 first. Names and my Lord, paragraph 6, names and the contact of persons affected on the side of the possible respondents. General Ibrahim Badamasi Babangida, President, Commander-in-Chief of the Armed Forces of Federal Republic of Nigeria, 1985 to 1993. I also refer, my Lord, to paragraph paragraph 6. It's paragraph 6, Roman figure F. And then finally, my Lord, the relief claimed by the petitioner. That is the last page. Relief claimed. We to recommend that two principal suspects, Colonel Halilu Akilu and Lieutenant Colonel Togun, for criminal prosecution for the murder of Delegiwa. My Lord, I would go first to the provisions of the 1963 Constitution. Now, before then, my Lord, I'll go to the second relief. It is compensation, including recommend the payment of by General Ibrahim Badamasi Babangida and the other three for the sum of 2 billion. My Lord, I did say I will refer first to section 161 sub 1 of the 1963 Constitution. May I with respect read. Without prejudice to the generality of section 156 of this Constitution, no criminal proceedings shall be instituted or continued during the period of office against a person to whom this section applies. And B, such a person shall not be arrested or imprisoned during the period either in pursuance of the process of any court or otherwise. C, no proceedings in which relief is claimed against such a person in his personal capacity shall be instituted or continued in any court during the period of office. Now, the relevant section is section 161 sub C. This is what I've referred to. Now, my Lord, going by this section, I will now refer to Section 267 of the 1979 Constitution. 267. May I, with respect, my Lord, members of the Commission, notwithstanding anything to the contrary in this Constitution, but subject to subsection 2 of this section, no civil proceedings or criminal proceedings shall be instituted or continued against a person to whom this section applies during his period of office. B. A person to whom this section applies shall not be arrested or imprisoned during the period either in pursuance of the process of any court or otherwise. And C. That is the important one. No process of any court requiring or compelling the attendance of such person shall be applied for or issued. Now, my Lord, I would now go to subsection 3. This section applies...
Read that one again, because the two you read talked about during the period of office.
Yes.
But the third didn't talk about that one.
Yes.
Read it again.
My Lord, I said, notwithstanding anything to the contrary in this Constitution, but subject to subsection 2 of this section. No civil or criminal... I'm reading now A. No criminal or civil proceeding shall be instituted or continued against a person to whom this section applies during this period of office. B. A person to whom this section applies shall not be arrested or imprisoned during that period, either in pursuance of the process of any court or otherwise. But C. No process of any court requiring or compelling the appearance of such a person shall be applied for or issued.
During the period of office is
Yes,
not
my Lord.
there.
Yes, my Lord.
And how do we interpret it?
I'm coming to it.
Good.
Yes, sir. Now, this subsection 3, applies to a person holding the office of president or the vice president, governor, deputy governor, and the reference in this section to period of office is a reference to the period during which the person holding such office is required to perform the functions of the office. My Lord, the event being complained of happened during the time President Babangida was President, Commander-in-Chief of the Armed Forces of this country. My Lord, I derive now support from an interpretation of this section of the 1979 Constitution from the ruling of your learned brother, Justice Enrique Fair, JSC. In this is attachment number 8 in the motion. Attachment number 8, page 5. My Lord, I don't intend to waste the time of the court, but let me read to the hearing of everybody. Section 161 of the 1969 Constitution provides as follows under subsection 1 of the 1963. Without prejudice to the generality of section 156 of the Constitution, no criminal proceeding shall be instituted or continued during his period of office against a person to whom this section applies, and such person shall not be accused or imprisoned during that period, either in pursuance of the process of any court or otherwise, and no proceedings in which a relief is claimed against such a person in his personal capacity shall be instituted or continued in any court during that period of office. He goes on, sir. The office is...
Did I hear you well? Can be continued during that period,
he held office.
I heard you well.
Yes, my lord.
Yes.
During the period he held office. The offices envisaged by the above are those of president and governor of the region. The necessity for the above provision seems to be to us obvious. It will be highly unsatisfactory. My lord, I did pray the indulgence of the court. I don't want to be distracted. When my learned friend was making his submission, I was quiet
Just
as
listen
a
to
snake.
the submission, and
Yes.
then if you want, if the court
He
wants
can-
you, if the tribunal wants you to react, you react.
Exactly,
Leave
my
him
lord.
alone,
Yes,
please.
my lord.
Everyone, not you alone. Every lawyer.
Later.
Down.
I don't know what he's doing, whether he's moving the motion or he's addressing the court in reply to what I've said.
Don't worry. We can control. We can control proceedings. Hold on.
Much obliged, sir.
Maybe, my lord, in the year 2000, my learned friend will come there and sit. Yes, my lord. The necessity for, I said 2003. You didn't hear me. It seems you're getting deaf too. The necessity for the above provision seems to us obvious. It will be highly unsatisfactory, to say the least, to have a head of state who, instead of devoting his energy to the affairs of the state, is being dragged from court to court over one cause or the other. This provision was retained by the military, and by way of modification, the function ascribed to the president under the first constitution became vested in the head of the federal military government, while those of the governor of a region became vested in the military governor. Decree 32 of 1975, section 15 thereof. The protection above, outlined above, is that a person of the holder of the office as opposed to that office itself. Thus, such peremptory applications like mandamus certiorari could lie against the president or the head of the federal military government. The relief sought against the president of Nigeria by Shugaba is a case in point. The application is not against Shehu Shagari in person. Indeed, the Constitution of Nigeria of 1999, as could be seen, inhibits such a step. Now, the very vital parts of this ruling is the last batch. Now, section 267, subsection 1 thereof, that no process of any court requiring or compelling the appearance of such person shall be applied for or issued. I go on. It thus seems to us that for the purposes of argument merely, even if we had been so minded to do, it would have been futile to issue process on the incumbent head of state of government, that is Shehu Shagari, to enable him testify before us in respect of the period 1st October 1979 to December 1979. Assuming that this inquiry were possible during the military era, as to which we have doubts, it would have been impossible to compel the general to testify. It is our view that the evidence now required of him, being matters affecting his performance in office as head of state at the time, such matters being clothed with immunity he had at that time, it would be odd indeed if we could now, as it were, remove this immunity retroactively, as it were, in order to compel him to testify. We are certainly not so persuaded. We are aware that Dr. Azikiwe, a former head of state, went to court over his tax matters, but it was he who brought the action. We are also aware that the general has reported in the press, sued a newspaper in his own private capacity since retiring as head of state. But these are different circumstances. The provision in the decree setting up this tribunal, which allows us to call or summon witnesses, cannot override the provisions of the most fundamental of our laws. That is the Constitution. We have given this matter most anxious consideration, and we'll come to the conclusion that it will be wrong, even if the general were so minded to give testimony before us, for the reasons stated above, and that a case for the impossibility of getting the desired evidence from the NNPC and other witnesses had not been made. There seems to be no difficulty in the people of this country at amending the Constitution as provided with in order to compel our heads of state, heads of our government, past, present, and future, to face public probe during or after their tenure in office. Just 1 minute. We refuse to set aside the president here. The witness summons issue, therefore, is hereby set aside. My Lord, this provision of the 1979 Constitution is in pari materia with Section 308 of the 1999 Constitution. Yeah, thank you very much. My Lord, may I, with respect of my Lord Chairman and members of the Commission, read the same provisions in pari materia with that of 1963, that of 1979, replicated in 1999. Section 3081. Notwithstanding anything to the contrary in this Constitution, but subject to subsection 2 of this section. A, no civil or criminal proceeding shall be instituted or continued against a person to whom this section applies during the period of office. B, a person to whom this section applies shall not be arrested or imprisoned during that period, either in pursuance of the process of court or otherwise. C, very material, no process of any court requiring or compelling the appearance of a witness to whom this section applies shall be applied for or issued. My Lord, it repeats ad verbatim literatum subsection 3 to include the president, the governor of the state. My Lord, it is my submission that the events leading to the gruesome death of Dele Giwa occurred when President Babangida was head of state, commander-in-chief of the armed forces. And it is my submission that this court should adopt the precedent laid by Irikife by quashing the witness summons issued to him, because this is really investigating something done when he was in the office. Yeah. My Lord, the next question is this, referring to Section 5. Section 5 of the Tribunals of Inquiries Act. My Lord, it says, subject to the provisions of this act, a tribunal shall have and may exercise any of the following powers, that is to say, A, power to procure all such evidence, written or oral, and to examine such persons as witnesses as the tribunal may think it necessary or desirable to procure or examine. My Lord, the use of that word may in that section is discretionary. It is not peremptory, nor obligatory. By implication, can this tribunal get evidence to make its recommendation from sources other than President Babangida? My answer is in the affirmative. The police can supply vital evidence. Babangida in person is not accused of murdering Dele Giwa, because the petition takes the form of pleadings, and you don't go outside your pleadings. The regime of President Ibrahim Babangida, it's not personal. My Lord, this commission is a fact-finding commission. It has no investigative or adjudicatory powers. Now, but the procedure now adopted by this commission, salutary and effective as it is, takes the form of procedure in a civil court. The petitioner leading evidence, calling his witnesses, who are examined in chief, cross-examined, and if there's any re-examination. So, my Lord, there is no procedure adopted by this court other than procedure in a civil court. Therefore, my Lord, it is my submission that even cases cited by my learned friend, the learned brother Silk, relate to civil proceedings. And therefore, my Lord, I will submit that there is no rule or law or even the practice of this commission which requires a plaintiff for a defendant or a respondent in this matter to be physically present in this commission and physically testify. No rule. My Lord, in this matter, there can be no question of proof. All the court is interested in, give us enough facts that will enable us write our recommendation. And enough facts that will enable us file our recommendation. I will say with respect, with all due respect and humility, that the petitioner can give this commission enough facts. The cross-examination of the witness, of the petitioner, his witnesses, and the witnesses President Bhagavan may be allowed with the leave of the court to call, will give this commission enough facts for the commission to make its recommendation. My Lord, in this regard, I will refer to 3 cases in this regard. The first one is the Cross River State Newspaper Corporation, Cross River State Newspaper Corporation versus Mr. J.J. Oni and others. My Lord, this is reported in 1995, 1 Nigeria Weekly Law Reports, part 371, page 270, at page 29293, paragraph D to E. 95, 1 Nigeria Weekly Law Reports, part 371, page 270, at 293, especially paragraph 9D to E. My Lord, it's the lead judgment of IGU JSC, and I crave the indulgence of this commission just to read the extracts which are relevant to my argument. Which one is that? Open it. I marked it, the end of it. What is 293? 293. 93 page. Yes, 293. Yes. Lord, may I read? May I read, my Lord? The first point that must be made here is that there is no rule of law or practice which requires a plaintiff in a civil suit to be physically present in court or to testify if he can otherwise prove his case. Indeed, it ought to be mentioned that there is also no such rule which compels a defendant in a civil suit to appear before the court and to testify before it. He can successfully defend an action against him. My Lord, the other case is the case of Sani Kehinde versus Amole Ogunbimi. My Lord, this is reported in 1967 Nigeria Monthly Law Reports, page 40. My Lord, it is almost representing word for word the ratio by Justice Igu in the case of Cross River Newspaper Corporation. I don't need to read it so as not to waste the time of the commission. The last case...
Let's get ourselves in order. Igu was 1995.
Igu was in 1996, my Lord.
1996.
Yes, my Lord.
And Sani Kehinde in 1967.
1967.
So Igu borrowed from him.
Either can borrow from each other.
Igu borrowed from him.
I'm not a Supreme Court judge here. My Lord, would they decide? I don't want to be charged of contempt. My Lord, the last case on that list, which I would refer to, is the case of, where is my write-up? No, my write-up. Oh, God. Case of British. My Lord, I did give the wrong citation for Kehinde for another case. Kehinde's case is 1967. I'm sorry for the slip. One all Nigeria law reports. One all. Kehinde, my Lord.
What year?
I say 67.
67.
But it's one all Nigeria law reports. Page 306. It's also reported in 1968 of the Nigerian Monthly at page 337. My Lord, is reported, the last case is British and French Bank Limited versus Solel. Solel is spelled, my Lord, S-O-L-E-L hyphen E-L hyphen Assad, A-S-S-A-D, 1967, 9 NMLR, Nigeria Monthly Law Reports, page 40. My Lord, my contention is this, that this commission can, with all due respect, unravel the facts surrounding who was the perpetrator of the gruesome murder of Mr. Dele Giwa, for it to make its recommendation to the appropriate authority. And the presence of Ibrahim Babangida, General Ibrahim Babangida, to recap what happened when he was in office, might not even be necessary. It's not necessary. That's my contention. In fact, the witness summons he directed to him to come and appear in respect of the murder that happened when he was in office. Yes, sir. My Lord, that's not the intention of the law. And in this regard, I would even crave the indulgence of the court to even look at the memorandum presented by Chief Afe Babalala on behalf of the president of this country. The president appeared because he waived his immunity. It's a matter of choice. He waived his immunity and came in. It's a matter of choice. So his appearance cannot be the yardstick why President Babangida should appear and testify. He waived his immunity. It's a matter of choice. But in 1970, 80, he refused to appear. And the Irikife upheld this thing. The witness summons should be quashed. We wouldn't have allowed you to come and testify over what happened when you were military head of state. My Lord, I would say that the petition of the petitioner has not been amended. So that why I'm saying this is that the petition stands like pleadings in a civil case. He cannot now deviate to call out Okon, Gloria Okon, and the rest of them, and Babangida killed Dele Giwa. There is no evidence that Babangida killed in his person, killed Dele Giwa. No accusation, except from the bar. My Lord, I now go to some of the sections referred to by my learned friend, the learned senior, the new senior advocate, the millennium senior advocate. Now, my Lord, I refer to Section 10 of the Tribunals of Inquiries Act. My Lord, Section 10 has a proviso, provided that no person shall be bound to incriminate himself, and every witness shall, in respect of any evidence written by him for or be given by him before the members, be entitled to the same privilege, to which he would have been entitled if given evidence before a court of justice. Immunity is a privilege. And the former head of state, Ibrahim Babangida, with all due respect and humility to this commission, is entitled to that privilege. Privilege from appearing and testifying himself. My Lord, I refer
us to go along together.
Yes,
If you read that proviso,
yes, sir.
provided that no person shall be bound to incriminate himself, isn't it?
Yes, sir.
That is, if he goes in there, he can refuse to answer a question that is
true, my Lord.
incriminating.
But the conjunctive word and.
Hold it.
Yes, sir.
And every witness shall, in respect of any evidence written by him for or given by him before the members, be entitled to the same privilege to which he would have been entitled if giving evidence before a court of justice.
Yes, my Lord.
Now, doesn't this presuppose his appearance first before
No.
he claims this immunity?
It does not.
He can stay at home and say, claim this immunity.
We have filed a response.
I see.
We filed a response. So it serves the same purpose, sir.
All right, we'll
Yes,
look
sir.
into that.
Now I go on to Section 12. My Lord, President Ibrahim Babangida cannot be accused of contempt in not appearing before this commission. My Lord, there is a matter pending in the Federal High Court, a reference to the Court of Appeal, questioning the constitutional validity of this commission. Well, I see one member nodding his head in disapproval. But this is a statement of fact and law. My Lord, I agree. There is no order stopping you from proceeding. But it is a law that even when there is no motion for stay or anything, and the commission is aware that a matter is pending in court, the commission will bow to it. I agree, sir. There's no order. But the commission is aware, because it's asked many times, what is the fate of this case? Even if there is no order, or the order had lapsed after 14 days according to the Federal High Court rules, this commission is bound in conscience to respect that pending proceedings in court. And if a man is exercising his constitutional right of seeking redress in a court of law, my Lord, he cannot be accused of being in contempt of this commission. I will refer to section 12(1)(c) of this Tribunals of Inquiries Act. Any publication calculated to prejudice any inquiry or any proceeding thereof is contempt. The display of this and that is capable of prejudicing the mind of the commission. There is nothing as contemptuous as this. So if somebody is saying Babangida is in contempt, he should first be charged of contempt, because this is contempt in facie curiae, the commission. What paragraph? My Lord, I also refer, my Lord, to the national interest of Saturday, August 18, year 2000. Still in contempt. The other time I was being told that I could not even display the picture of Dele Giwa. What the hell is that? I mean, somebody was murdered, and you could not even display the picture. What kind of inquiry is that? I will go there with the picture of Dele Giwa. I will also go with the picture of Dele Giwa before he was killed, because I want them to see the man in suit, that handsome man in suit that they murdered. So I can't understand. What is it in the picture that I cannot bring to the tribunal? So now the litmus test of that tribunal is Dele Giwa's case. You see, and despite this, the learned senior advocate has done it again this morning. I don't know what can be more contemptuous of the provisions of section 12(c) than this one. Now, what else again? My Lord, a subpoena ad testificandum, or a subpoena duces tecum, is a process adopted in civil procedure. It also applies here. So there's no difference. And the cases cited by my learned friend are really apposite. I conclude, sir, that appearance by counsel on behalf of President Babangida, who was not personally indicted with the murder of Dele Giwa, it's the same thing as his appearance. And he need not physically appear, how much more testify? My Lord, I refer to section 18 of the Tribunals of Inquiries Act. Appearance. My Lord, it says this: any person whose conduct or affairs are the subject of inquiry under this act, or who is any way implicated or concerned in the matter under inquiry, shall be entitled to be represented by counsel at the whole of the inquiry, and subject to paragraph D of subsection 2(1) of this act, any other person may, with the leave of the members, be represented in like manners. My Lord, the unfortunate thing is that the draftsman of this law did not insert section 2(1)(d). There is no section 2(1)(d). And it is a lacuna which maybe a trick of memory of the draftsman did not address itself. There's no section 2, subsection 1D of the Act, the Tribunals of Inquiries Act. And we cannot fill a gap, my lord. We can't fill the gap. Yes, sir.
No section.
Did you say, sir?
No, repeat that one. Let me look at
I said under section 18.
18.
Yes, my lord. It says, and subject to paragraph D of subsection 2, sub 1 of this act. My contention is that there is no subsection 2D. It might be a trick of memory of the legal draftsman.
Yes.
It's not myself, as Gani Fayemi would insist it was me when I was attorney. Brother. It's his brother. My lord, it is my contention that General Babangida does not need to appear. This commission will have all the available evidence from the police, from those who have testified if they are cross-examined by leave of this commission, to give the commission enough facts that will enable you to write your recommendation. The presence of Ibrahim Babangida is not necessary. Is there any other thing? No. That does it. Well, the material witnesses can be given. Material witnesses, they are here, the police. Zadok is here. Omeben is here. Kaltungo is here. These are police service chiefs.
When Chief Gani Fayemi trespassed into the facts,
well,
I stopped him.
I leave the point.
Exactly.
I take the tip from the commission.
Nearly everything you've been doing is the facts.
I withdraw that, sir. I withdraw that, sir. I withdraw that, sir. My lord, I think I am done. That I have said that Ibrahim Babangida is not guilty of contempt. You see, my lord, the case cited by my learned friend involving Kasumu, there was a subsisting order of court. And instead of obeying the court before setting it aside, it did not mean that he was advising his clients not to appear. The same thing applies to us. A man is exercising his constitutional right of going to court, and you say he's in contempt. I mean, Lord, some of the exceptions in the rule against contempt is that if you are appealing against the same order for which you are in contempt, you cannot be said to be in contempt. I pray the indulgence of the court.
Before I go to the next council, let me clear some cobwebs in my mind.
Yes, my lord.
Can we start with section 5?
Yes, my lord.
C.
5C.
Yes. Power to summon any person in Nigeria
Yes, sir.
to attend, not to appear, to attend
Yes, my lord.
any meeting of the tribunal and to give evidence
Yes.
or process or produce any document. Power to attend. So when you lawyers talk about appearances, don't confuse power to attend and appearance. Fortunately, unfortunately, the form appear is only used in the form, the summons. Form A
Yes, sir.
talks about witness summons. Witness summons.
Yes, my lord.
You are hereby summoned to appear. That's where the word appear
That is true, my lord.
appears.
Yes, sir.
But in the act itself,
Yes, sir.
there's nothing like appear.
Nothing.
Power to attend.
Attend.
Good.
My lord, there is no...
No, I haven't finished.
Very, very well.
If power to attend is to, which one, if there's a bit of difficulty between the form and the act,
Yes,
which takes precedence?
The act would.
Of course, the act takes precedence.
Yes, sir.
So we are now talking about power to attend.
Power to attend.
Uh-huh. Suppose we read that section. Read, have you got it?
I do, sir.
Read it, section C.
The power to summon any person in Nigeria to attend any meeting of the tribunal, to give evidence, or produce any document, or other thing in his possession, and to examine him as a witness, or require him to produce any document or other thing in his possession, subject to just exceptions. Subject to just exceptions.
Good. Now we'll go back to...
Subject to all just exceptions.
Yes. Have you got our terms of reference?
Yes, my lord.
Good. If you look at them.
Can you give me a copy?
To ascertain, establish the causes, nature, extent of all gross human rights violations, identify the persons, authorities, institutions, organizations which may be held accountable.
Yes, my lord.
Accountable for such gross violations of human rights,
Is it mutually?
and determine the motives for the violations or abuses, the victims, circumstances, and as affect such victims, society generally, of the atrocities. Determine whether such violations or abuses were the product of deliberate state action, state policy, or the policy of any of its organs or institutions, or whether they arose from the abuse by state officials of their office. Recommend measures which may be taken, whether judicial, administrative, legislative, institutional, to redress the injustices of the past and prevent or forestall future violations or abuses of human rights. If we stop there, our terms of reference, are they not wider than the summons for a particular victim?
My lord, they will be wide.
Very wide.
My lord, it is wide, but you have to relate it to the facts of each particular case.
Without anybody mentioning any victim,
Yes,
can't we summon a witness to help us to answer some of the questions here?
My lord,
No mention of any victim at all.
I agree, my lord. My lord has said that attendance is different from...
Can I have the summons?
Yes.
What the summons
Yes, sir.
says?
I hereby summon to appear as a witness. My learned friend is arrogating the witness to be an accused.
I like to be, all of you who haven't addressed, take this. Must the commission confine itself to a particular petition, or can the commission summon witnesses to help us answer everything in the terms of reference?
No, my lord, that would be a wild goose chase.
Why?
You don't call somebody to ask him everything that happened relating to every other abuse of human rights.
No, that's not it.
No, sir. You see?
Every head of state,
Yes, sir.
every governor, every executive is accountable
Yes.
for things done during his tenure.
But I said no, sir. That's my submission.
If we agree there.
Yes, sir. That's
if
my
we agree
submission.
there,
Yes, sir.
Suppose we want them to let us know what happened. Not Delegiwa, no Delegiwa.
Supposing they say they will not because it happened when they were in office.
It doesn't matter if they say they won't come. That's a different consideration.
Exactly, my
But
lord.
have we the right to ask them to come?
You can, but they will say no. I have immunity.
It's all right. Once
Yes,
you
sir.
admit we have the right to ask them to come.
Yes, sir. You
Whether
can.
they obey or not will be another consideration.
Exactly, my lord.
Which we may go into. See? Now, But you agree with me that from the terms of reference,
Yes, my lord.
every top government functionary
Yes.
from 1966 to 1999
Yes, sir.
will be in a position to help us find out what happened to this country.
I agree, my lord. If the man has evidence, oral or documentary, which cannot be obtained from any other source. Yes. Because after all, the secretary to the present government is...
All right, let's go back to the
Yes.
section 5.
Yes, sir.
5A.
Yes, my lord.
The power to procure all such evidence, written or oral, examine all such persons as witnesses as the tribunal may think it necessary or desirable. Suppose we think that they are necessary witnesses. Have we got a power to summon them?
My lord, I would answer that question.
That they have an immunity not to come?
My lord, this is the purport. If this commission can get evidence ab extra Babangida, outside Babangida.
Why if?
No, my lord, because
Why if?
there are
Hold it,
people.
hold it.
The,
If
the-
it
the
hasn't come
police-
in yet,
Yes, my lord.
we as a commission
Yes, sir.
think they can help us.
Yes.
And the commission and the law allows us to call all such persons as we may think necessary.
Yes, sir.
And we think they're necessary.
Discretion.
All right. Bit by bit. Number one, are they relevant witnesses to talk about what happened during their regime? Are they relevant?
With the present setup, they might not be relevant because they're out of office.
It doesn't matter whether they're out of office or not. They're accountable first to the electorate. Second,
My
to
lord,
Nigeria.
my lord,
Third, to
yes, sir.
posterity. So
I agree.
whether they're in office or out of office,
I
neither
agree.
here nor there.
I agree. But the Constitution says processes must not issue.
We shall,
Must not
consider, we
issue.
shall consider that.
Yes, sir.
We shall consider that.
That's what the Constitution says. The processes must not issue.
all right.
And we are bound by the
All
ground.
right.
Yes,
all
sir.
right.
Yes,
Let's
sir.
see. If we are all Nigerians
Yes, sir.
and we're all interested in reconciliation,
Yes, sir.
need we be all that legalistic? Need we?
My lord, it is the law that set up the commission. Why can't we be legalistic?
All right. That is a submission. Now,
Eh?
we note it down.
Then anybody can get up and say, Justice Oputa, go and without an instrument.
I hope it's law you're talking about.
Yes, sir. It is law. It is law I'm talking.
No, I'm not talking about you.
Yes, sir.
It's a commissioner who wants to talk,
That's right.
who is not learned like you are.
Well, my lord is better learned than me. But I'm a senior advocate of 16 years standing. Yes, I mean, that is Spring Cordial.
Actually, I just wanted to make my own observation as a layman, because I feel like a hostage. I mean, held hostage by these legal technicalities. I hope that those making the addresses will please take into cognizance the fact that we are not all lawyers, and that the issues on the ground, as far as some of us are concerned, are issues of social responsibility. And I think we can go round and round in circles, but the fact of the matter is that we are now using law to deal with a period of our history that was an illegal period. You know, the period of military rule, which was not, we were not ruled by the rule of law. We were ruled by the suspension of law. And, you know, for me, that is really where a lot of the problems are, that if we are talking about the legal implications of appearance or non-appearance, I think we probably may need to focus a little bit more, because issues of this nature, commissions of this nature in other parts of the world are also about symbols. They're also about, there is a sense in which the appearance of a General Babangida or the appearance of a former head of state is not about law. It's about a symbol. And I think these are the things that it seems to me we need to be focusing on. As I said, in the final analysis, it's not so much a question of what is legal, There will be those who might argue that what is legal is not necessarily moral. But I just want to make the point that we might go round and round, but it does seem to me very clearly that the court of public opinion is very, very important. Yes. And the clients that we are talking about must be told that whether they appear before this commission or not, they are still before the court of public opinion. That, I think, is something that should be of great interest to all of us. So I'm not saying, I'm just saying that the legal aspect of it is getting a little bit confusing for me and very difficult for me to follow. And I believe a lot of other Nigerians. And I just hope that we all know that the process of reconciliation will not be achieved by law. A lot of these things will be what is in the heart, as opposed to what is in the head. So this to me is the point I wanted to make, that in the addresses, let us focus on law, but also look at the social dimensions of what we have experienced as a people. That's all I just want.
With all due respect to the Most Reverend Father, I think canon law is also applicable, not only. So, sir, I still maintain, because this morning the chairman asked us to address you on two vital issues for determination, which involves law. We can't run away from it. Yes. See, and my Lord the Reverend has sat so much in this commission that you almost abreast of the law now. You see. So, sir, I still think that law is necessary in this matter. You see, the public opinion, yes, but at times morality does not fit in with the law. They are concentric circles which may never meet.
Leonard Senior.
Yes.
Is it, do you agree in principle, reading section 5A?
Yes, sir.
That the power to procure all such evidence, written or oral, and to examine all such persons as witnesses as the tribunal may think it necessary, is a power that is exercisable at the instance of the commission. It decides of its own motion, without reference to anybody,
right?
If it is desirable that a particular witness be called.
Yes.
I mean, just a plain reading of this section.
But I am not trying to analyze the provisions of the statute.
No, no.
You're correct.
All right.
You're correct.
Now, but your position is that constitutionally, the powers, the immunity granted former office holders will preclude the exercise of these powers under the Constitution.
That is what I'm saying. I'm most obliged to.
No, I just want to understand.
This is what
your
I'm
argument.
saying, sir. This is what I'm saying. At least in respect of acts done when he was
while
head
they were
of
in
state.
office.
Exactly.
All right. Well, I want to understand.
Very well, my lord.
in the
I'm
consideration
much
of
obliged
the ruling.
about the
Because
explanation.
if we agree with you,
yes, my lord.
That
is the
if
end.
we disagree, then we can exercise this.
Very
power.
well. Very
All
well.
right. Yes.
Very well.
Then appearing by proxy, if you read section 5C and 10 together, that it really allow anybody to appear by proxy.
5C and 10.
And 10 together.
Yes, sir.
And if you draw the distinction between civil proceedings, although he said they are like civil proceedings.
Same thing, sir.
But summons here is not like a civil, summons in a civil proceeding.
My lord, summons is summons.
I know.
Appear.
And here they have stated what will happen if you don't come.
Well,
in civil proceeding, if you don't come, they go on with the case.
No, my lord, but
This is more than just going on with the case.
there can be a sanction even if you don't appear, except the judge is not interested in enforcing that sanction.
Well,
Yes.
do you agree that section 5C and 10 read together will not permit appearance by, because section 5C talks about appearance, attend to give evidence. That will exclude appearance by proxy. Forget delegate, forget every, just section itself.
My lord, I think it's a play on words. I say this because one cannot, as a witness, come and sit here without being summoned to go into the witness box.
Give evidence of what happened in Nigeria, not the delegate.
No, evidence of what transpired is personal things, sir. Evidence of what transpired who were the perpetrators of this gruesome murder. It's not a
I'm not talking about Dele Giwa as Dele Giwa. I'm talking about what happened in Nigeria between 1966 and 1999.
Yes.
If anybody can help us,
yes,
to my mind, that somebody is a necessary or relevant witness.
yes.
When we invite him, then we know what we're inviting him for. That leads to another question. Can we really foreclose, that is, restrict questions on what appears on the petition? Or can we ask from a witness anything he knows about what happened during the period under review?
My Lord, the problem that has gone on is that counsel are allowed to raise even matters not within the terms of reference.
Not within a petition.
Yes.
Can't we go beyond the petition
Well, my Lord, that will be...
in view of our terms of reference?
Well, my Lord, it depends, really. It depends. If you summon me to appear in respect of a specific thing, well, if you ask me anything outside the reference, I reserve the right to say I don't know.
Or you reserve the right to say, I'm not prepared for this, I'll come another day.
Yes, sir. No, but he can say, I don't know. Coming another day will not help.
It's all right if you
Yes,
say
sir.
I don't know. It's all right. That's an answer.
Yes, sir.
That's an answer.
Right, sir.
Can we see a copy of the summonses? Let me see what the summonses say. You are summoned.
Let me ask him. Let him continue to ask me. I'll answer.
No, this is a blank thing. This is a blank thing. This is a blank form. You haven't got any summons that you feel. Let me see what you have invited to come and do.
Yes.
This is blank, and this is all right. You are invited to come, someone to appear before the Human Rights Violation Commission, such and such a day, such and an hour, as you may be called there to give evidence respecting the inquiry into the conduct or affairs of what? I don't know. This is blank. If it's just the inquiry, then inquiry is our terms of reference.
There is what?
All right, we consider all those things. I just want to finish with him, so another man will. I want to, so that we can go along, instead of coming back to ask you questions.
Very well.
So when we finish, then we go to another with.
My Lord will not finish with me when you finish asking the questions. If you say finish me, then it will be extinction.
No, what I'm saying is that I didn't want to all the senior advocates to address before I take up point that
Very well, my Lord.
a bit foggy in our mind.
Very well, my Lord.
So that we clear all the fogs and
Very
all
well, my
the cobwebs.
Yes, my Lord.
So that when we are writing a ruling, we know what we are writing about. So you are saying they can appear by proxy. Witnesses can appear in spite of sections 5C and 10. They can appear by proxy, that's by counsel.
That is correct, my Lord.
That's what you are saying.
If you look
That's
at
your
section
submission.
5, it does not say from whom you get evidence. It's get evidence that documentary or oral that can help the commission make its recommendation.
The section 5 talks about coming to testify.
Material evidence.
Coming to testify, that's what
Material
use
evidence.
material evidence.
Yes, sir.
It says, come to testify.
Yes, sir.
It is when it comes that we know. Let me see.
Constitution says don't issue in the first instance.
Nobody can read this. It's not easy to read. All right, then. Thank you very much. for
Very
that.
well, I thank the commission.
Who is the next SAN?
Mr. Chair.
SAN? All right,
I'm
all
not
right. I
my
thought
lord.
we deal with
I'm a
SAN
party,
first.
but okay, if the aliens want to do it,
Just hold on. Let's finish with the SANs.
okay, of course, my lord. Go ahead.
My Lord, I did say, and honorable members of the commission, I did say earlier on that I am not in this matter, but my client is concerned and connected with this matter, in the sense that he is required by
We'll
this.
hear you. Don't make it. We will hear you. In fact, anybody among the learned gentlemen who want to give us any help, we will accept the help. Go on.
I do not want to belabor your lordship and honorable members of the commission. I want to go directly to the effect of Section 5, subsection C, and Section 18 of the Tribunal of Inquiries Act, vis-a-vis the provision of Section 36(1) of the Constitution of the Federal Republic of Nigeria, 1999.
Go slowly. This is very important. Go slowly, please.
I'm very
the
sorry.
effect of Section 5C
Yes, my lord.
and
Section 18
Section 18
of the Tribunal of Inquiry Act, Cap 447, Laws of the Federal Republic of Nigeria, 1990. Vis-a-vis the provision of Section 36, subsection 1 of the Constitution of the Federal Republic of Nigeria. And I think I respectfully submit that in this regard, it is the second question that is of fundamental importance.
Second question is what?
Can counsel to such a person be allowed to cross-examine witnesses to the commission if he himself does not appear? I watched with keen interest your lordship calling for the summons. And I think, in my respectful submission, that is the kernel of the matter. I would give an example, my lord. If, for example, the summons says, YXZ, come before this honorable commission to answer allegations made against you by witnesses to the commission, PQR. Can that person say, counsel, look at this. Have a look at the summons I have been given. My answer to these summons is not in what I will tell the commission myself. It's in what you will ask all those persons mentioned in these summons. It is in what A, B, C, D, who are not yet called by the commission, would tell the commission. In those circumstances, my lord, what useful purpose will the presence of that person serve before the commission? I concede one important point, and no one can run away from that, that your lordship has powers under Section 5C and Section 10 to punish any person in Nigeria who does not come before you. But that is besides the point. The heart of the matter and the kernel of the matter is, if an accusation is made against any person in Nigeria, can that person not be represented by counsel to cross-examine the witnesses to the commission who perhaps made allegations against him? I listened with rapt attention to my learned friend, my childhood friend, Gani Fawehinmi, SAN, who submitted that your lordship should disregard the provisions of section 36. Of course, he knows what he was. He knows what he was saying. If I come before you,
What does 36 say?
the right to fair hearing. He says, in the determination of his civil rights and obligations, including any question or determination by or against any government or authority, a person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal established by law and constituted in such a manner as to secure its independence and impartiality. I submit with utmost respect that your lordship's tribunal is such a tribunal, and that the right to fair hearing is enshrined in the Constitution. Fair hearing includes not only the presence of a person summoned to reply to allegations, as in our case, in the case of General Abdusalam Abubakar, because his own summons says, you are required to bring with you the following books, documents, or other things. That is to say, all relevant materials, particularly to enable you respond to the allegations against you. My lord, that is very important. We require you to come before us to respond to the allegations against you by the commission's witnesses, namely Lieutenant General Ishaya Bameyi, Brigadier General I.A. Sabo, Major Hamza Al-Mustafa, and Superintendent Zadok, relating to the death of Chief M.K.O. Abiola. In this case, that is what the man summoned is required to come and do. And he says, my counsel, these are the facts. Ask Brigadier Lieutenant General Ishaya Bameyi these questions. Ask for permission of the commission to recall him. Ask him these questions. Ask Brigadier General Sabo the following questions. Ask Major Hamza Al-Mustafa the following questions. By the time you finish with them, the commission will not need me at all. Is that not a possible situation? My humble submission is that that is possible. And in the defense of his rights, General Abdusalam Abubakar can do just exactly that. He will still be acting within the bounds of fair hearing. My learned friend submitted to your lordships, and this is very important. He says, once you refuse to attend this commission, according to this summons, you cannot be heard. I was waiting for his authority on this point.
He gave many authorities. Maybe you didn't write them down.
No, I wrote them down. I wrote his submissions down.
He gave many authorities.
You see, he said any person.
If you are in contempt of a court, you can't ask favor from the court.
My Lord, I am grateful. He said, amongst other things, that once you are in contempt, that's the end of the matter. But your lordships have said in Odogu and Odogu that look, the right to be heard, even when you are in contempt, will not be taken away completely from you. And my humble submission, what is even more, I think section 5C contemplates such a situation when it talks about, when it talks about subject to all just exceptions. And I submit with profound respect, my Lord, that the situation I have described earlier on is such a just exception, where a man's defense to allegations made against him lies in his obtaining admissions from the witnesses to the tribunal. He can then, in that situation, ask counsel representing him to crave your lordship's indulgence, to recall the witnesses to the commission and cross-examine them. That is his defense. Because the summons says, come and reply to allegations made against you.
Can you compare and contrast the summons under Section 5C and the ordinary summons in a civil case?
My Lord,
Have you got a copy of an ordinary summons in a civil case? See if they're the same or they're materially similar, so that the authorities quoted may or may not be applicable.
they are, my Lord, my first submission is that they are similar, but there is a difference.
What is the difference?
The difference is that your lordship is empowered by law to summon a person under Section 5C.
Unlike civil case where witnesses summon,
Yes, my Lord.
that's a very vital. Now that we admit that the commission has power to summon,
No doubt
Can-
about that. I concede that.
that is not in dispute.
No.
Section 5.
Yeah.
Now, do we restrict the summons or the evidence when they come to what is in a petition, or do we go to what is in our terms of reference?
My Lord, your lordship must look at the summons you issued to them. Your lordship must give meaning and effect to the summons you issued to them. Because
Agreed.
that is the only thing they
I
have
agree.
to go by.
Having come, having obeyed the summons, can we ask questions relating to the stewardship of all this during the tenure of their office? Can we?
My Lord, your lordship, we seem to part ways there. Because if your lordship asked them to come and respond to allegations, as in our case, allegations made by some of the commission's witnesses, the question that follows is, are they entitled, do they have the right to recall the commission's witnesses and cross-examine them? Will that not be the litmus test of
That
fair
has
hearing?
never been in dispute. The dispute is, will they have that right if they refuse to obey? It's not, you have a right to cross-examine. You have. Everybody has been cross-examining. The only issue is, if the principal parties refuse, party in quote, because no party here, that are witnesses, refuse to come, will they sit down and say, go and cross-examine them for me?
Will they not, my Lord, I submit that they will be entitled to do so, because that will satisfy the principle of fair hearing. Whereas, if your lordship says, I'm sorry, my Lord.
Help you. I don't know whether Mr. Bambo is aware that in spite of the court's order, we did write General Babangida that he may, if he so desires, respond. We did.
Yes,
Are you aware of that?
yes, my lord.
That's referring to the question of fair hearing.
Yes, my lord.
Good.
And we responded.
Yes, we did ask him.
Yes, sir.
He can write us a letter.
Yes, sir.
So
In
that
fact,
answers your question.
In fact, that letter was signed by his lordship.
So that answers your question that we did even write to General Babangida in view of the court's decision that you can't come. We are not asking you to come, but it will be unfair to you if the commission makes any recommendation in the absence of your responses. So we sent him that letter. That confirms what you are saying. Whether they come or not, they can respond.
I'm grateful, my Lord.
Having agreed with you thus far,
Yes, my Lord.
what about our terms of reference? What do you think of them?
They are very wide, my Lord.
Very, very wide.
Yes, my Lord. And encompassing.
They are wider than any petition.
Yes, my lord.
Good. Do you agree with our suggestion that people who were the helms of affair will be the most likely people to help us determine some of these terms of reference? You don't?
My lord, that is a very tricky question. It is a very tricky question.
Well, let's leave law alone. Let's leave tricky alone. In the spirit of reconciliation, can you have two people who don't want to meet face to face reconcile? They have to meet and talk before you talk about reconciliation. And our main job is to try to reconcile those who have been injured and those who thought they were injured with their alleged or supposed. You see, if we are working towards reconciliation, as many other commissions in other parts of the world, they didn't adopt a legalistic approach to reconciliation. We'll be discussing law and this country will be burning, like Nero fiddling while Rome was burning. And you all at the bar have a big responsibility to help us succeed.
My lord, as I was saying, my lord, anyone confronted with these summons, the summons in our case.
We've agreed with you there, but I raise another issue. Looking at our terms of reference, are these erstwhile executives, top executive, not those who help us answer some of the questions, whether they were mentioned in a petition or not? You don't want to answer that one?
That is a question blowing in the winds. It is tricky. It is tricky in the sense that
all right then, we'll go to another one. Have you finished?
My lord, that in the main will be my argument in favor of appearance by counsel in respect of General Abdusalam Abubakar. And I want to say, my lord, that...
All right, suppose we agree with you. What about appearance by counsel in respect of other things mentioned in the commission? What happened in each man's regime? Will you answer that?
That will not be dealing with the exercise of your powers under Section 5C.
We can go outside that. Under Section 5, not A, not B, Section 5 alone.
Yes, my lord.
Read it again. The power to procure
Yes, my lord.
all such evidence,
Written or oral?
written or oral,
Yes, my lord.
and to examine all such persons as witnesses, as the tribunal may think it necessary or desirable. Now we say it is necessary for every head of state to come and tell us what happened during his regime. Not whether delegate or this or that. No. Generally, what happened. And also, if you look at the other terms of reference, to help us make recommendations on how to forestall these things happening again. That is our headache. If we do not ask them to help us, we will be guilty of treating this commission with levity. They're the only people who can tell us that it will not happen again. Adopt so. But if you say we can... They haven't even... Yes? What do I write? A trickish question.
Trickish in the sense that it does not deal with the summons which my client...
I've agreed with you there that he will come and give evidence only as directed by the summons. Yes. But if the commission decide that they may get more from him, are we disbarred from asking more from him?
Until we get there, my lord.
That is why we want him here. All right. Yes. Let's hear another SAN.
Very well, my lord. That will be my submission.
Thank you, ma. So what do I write? That is a trickish question.
No, what I want your lordship to write, with respect, is that that question does not apply to my client, General Abdul Salam Abubakar, in respect of the summons he has.
All right, all right. Yes, another SAN.
My lord, I'm of the view that it is not mandatory for a defendant to appear. Let's say, for example, now, sir, that there is a plaintiff. He will start his case. Indeed, he doesn't have to be in the witness box. All the witnesses will be cross-examined, including the plaintiff. And all the necessary information can be extracted from the plaintiff and his witnesses. At the end of the day, as a defendant, let's say, for example, the general or the generals involved, I might now say, I close my case, no case submission. You know, that's the point, sir, because all the answers, information that the tribunal might need can be extracted under cross-examination from those witnesses if they are recalled. And then they will say, I'm sorry, sir, we don't have to call my client anymore. That means counsel can address without the presence of the other parties.
That is in a civil case.
My lord, it's the same procedure, sir.
Hold it. When persons are ad litem, are anybody ad litem here? Is there a list here?
My lord, virtually there's no list. But my lord, what I'm saying
is there a list here?
There's none, my lord.
Yes or no?
I will say yes, my lord.
Yes. What is the list? Between whom and whom?
My lord, it's between those who came and gave allegations or made allegations against a particular person. The allegations are the list.
Civil law talks about parties.
Yes, sir.
No section of inquiries, Tribunal Inquiries Act talks about party.
My lord,
we cannot witnesses.
My lord, we cannot run away from it. My lord, when we have a panel like this, there are bound to be parties. Though, my lord, I'm sorry, sir. Those who came and made allegations.
What do you define parties in law to include?
I'm sorry,
parties.
sir.
What is the definition of party in law?
Plaintiff, his witnesses.
Is there a plaintiff here?
My lord, with due respect, sir. My lord, no, I'm sorry, my lord, I'm sorry, sir. If anybody enters that box and made allegations against me, as far as I'm concerned, I will call him, well, a complainant. And I become the defendant. While I'm asking him various questions, there may be need for me to say, I do not want to go into the box. I have no case to answer. My lord, I'm submitting, sir, that the witnesses can be recalled. We can ask more questions, extract parts, all we need. At the end of the day, sir, my lord, I'm sorry, sir.
Are we in court here?
My lord, this is a quasi-court. Quasi-court, sir. You have all the powers of a judge. You can commit people for contempt of court. We are in court, sir. That's my submission, sir. That I maintain, sir, that from the witnesses, we can get all we need and say, I won't call my client. No case submission. Yes, sir. I'm sorry, sir.
Can help us if you...
Oh, I'm so sorry, sir. I spoke before my learned senior. I'm sorry, sir.
May it please your lordship and members of the tribunal.
Yes, please.
Commission.
This is a very important chapter. Suppose there was no legal man on this side. What do you do?
All right, then. The lawyers are dragging it down.
Go on, please.
I think perhaps there is need here to understand the true nature of the proceedings before your lordship's commission. As against judicial proceedings between parties, like in a civil action. Generally speaking, in a civil action, there is a claim, there is a dispute between a plaintiff and a defendant. They are parties who are engaged in adversary litigation. When the plaintiff initiates the action, the summons, the writ of summons, is what is served on the defendant. And the defendant has a choice whether he will respond to it or whether he will not. No one can compel him. No court can compel him. All that the court can do, and will almost certainly do, is to give judgment against him for the claim, and that is the end of the matter. But he may decide that he wants to defend, but he does not himself want to be present at the trial personally. So he instructs his lawyer to appear on his behalf. He files an acknowledgement of service. If he files his defense, on the day of the trial, he does not have to come if he does not want to give evidence, so long as he's represented by counsel. He does not have to give evidence himself in the trial. And the trial can be concluded, his counsel can argue on his behalf, and even eventually, without him coming, win the case if his case is well put. But the plaintiff in that case, however, can still compel him to come to court by issuing a witness summons. Now, I was asking the defendant to come and give evidence on his behalf, on his plaintiff's behalf, if he wants to take the risk. And once he tenders his expenses, the defendant must come. If he does not appear at the trial in answer to that witness summons, the courts can issue a bench warrant to bring him to court. And if he does not give a satisfactory explanation, the court can punish him. Because that summons, that witness summons, is an order from the court for him to appear. He has no choice. And here, he cannot send a message to the court and say, I want my lawyer, this is what I would have wanted to say. Let my lawyer say it. His lawyer cannot say it for him. Nobody else can give evidence for a party.
In respect of a witness summons.
In respect of a witness summons. But the mere fact that he refuses to obey the witness summons to come and give evidence does not disentitle him to pursue his substantive defense of his case. The court can only punish him for refusing to come. His substantive case can be conducted by his client, his counsel. As against that is the proceedings before a tribunal of inquiry. The tribunal inquiry is a totally different institution from its get-up, from its focus, from an ordinary court of law. It has its own terms of reference. And it has its own counsel, which a court never has. And the approach and the procedure is so different. The procedure for the conduct of business, which your lordships have, members of the tribunal have outlined for this tribunal, make this so very clear, the difference so very clear. It is the counsel to the tribunal who will call witnesses. Any witness who comes here will be called by the witness of the tribunal, who will take him or her through the evidence. And all other counsel cross-examine that witness called by the tribunal. So even if that witness is called in support of my own case by the tribunal, I will be cross-examining that witness. So that witness now is in exactly the same position as a witness summoned in ordinary litigation, in adversary litigation. He has an order from the court, from the tribunal, to come and give evidence. And he must answer that summons personally and give evidence and answer questions that are put to him on pain of punishment. And I think the last clause in that Form A makes it quite clear. After setting out what he should do and the documents that he should produce, it says, herein fail at your peril. If he does not come, he runs the risk of punishment. And the form is there. The Tribunals of Inquiry Act provides for the sanction for anyone failing to obey your summons. You're entitled to issue a bench warrant for that person. And he must come and satisfy
you. Do you regard Section 5, summons under Section 5, as a writ of summons or as a
it's a witness summons?
Witness summons.
It's an ordinary witness summons. It is not summons in adversary litigation initiating an action. It's an ordinary witness summons.
The point we'd like you to help us, this point made that under the Constitution, you cannot even issue the summons. What's your reaction there?
Under the
Constitution, we can't even issue this witness summons.
You can't issue a witness summons under the Constitution?
By Mr. Bambo, SAN.
Oh, in respect of a former head of state?
Yes.
Oh. Well, I must say, my lords, I think perhaps the decision given by late revered Justice Ridikebe perhaps is one of the most unfortunate and embarrassing decisions given on the constitutional position in this country. It's most unfortunate, and we all wish that we forget that decision forever, because it is not right and cannot be right. Because the Constitution qualifies it that a head of state is only exempted from court processes during the currency of his term of office. It is very clear.
When Mr. Bamba was reading, yes, I drew his attention to A, they said during, yes, B, yes, they said during, C, they kept, yes, quiet. Yes. So I asked him, what is the interpretative jurisdiction of this, of a court, not here, not a court.
Yes.
If you have a section A, B, C, yes, something is repeated in A and B and omitted in C, yes, how do we interpret it? I wish the Supreme Court would go into that one day.
The interpretation of any section of any law has to be made within the context of the whole document itself. You cannot interpret a section, a subsection of a law in isolation. And it's quite clear that the intention is that the former head of state, the head of state would be exempt during his term of office. The subsection that follows it makes it also quite clear that it provides that the period of limitation, normal period of limitation, will only begin to run against a former head of state on the cessation of his term of office. And I think the prohibition against the issuance of process against the head of state is so clear that the Constitution makes it clear that it is only for that term that the exemption subsists. And that is why that provision is there with regards to the fact that the Limitation Act does not begin to run until he ceases office. In fact, that is actually saying that after he ceases office, then he is liable to this process.
He becomes an ordinary citizen. After he ceases to be head of state,
yes,
he becomes an ordinary Nigerian.
Ordinary citizen, yes. 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 That is all I propose to practice.
Thank you for the... Another senior advocate who? Let's hear you.
Yes, my lord. My lord, I wish to add for purpose of emphasis that the proviso to section 308 of the 1999 Constitution operates only for the period when the head of state is sitting on the stool.
You are agreeing with your learned?
I agree with him, my lord. And I must add this, my lord, that in other jurisdictions, as events have shown of recent, even that immunity is being done away with or is being watered down. And I'm referring to the Bill Clinton experience in the United States. My lord, notwithstanding that provision, he was taken to court and the matter was entertained. So perhaps we in this country, now that...
Have they got such a provision in their constitution?
I'm not too sure, my lord,
well,
but I should...
How can you compare? They have it.
They have, my lord, they have. It was waived during Nixon, and during Bill Clinton, the same thing happened. So the bottom line of it, my lord, is to say that, quite frankly, the provision is to enable the president or the governor perform his constitutional duties uninhibited by court processes and so on and so forth. It certainly will not apply while he has left office.
Next question that will help us. Our terms of reference just very, very wide. Can we ask the functionaries, the executive functionaries, to help us make useful recommendations, not asking them about the murder or about the detention, just to help us determine what the former heads of state, since they were in power then. And one section of our terms of reference talks about atrocities committed during those period.
Yes, my lord.
Will they not be very useful witnesses?
In such a situation, my lord, is either they come themselves, or if they are aware of relevant departments of government, which will come before you with pertinent evidence. It is my humble view, my lord, that this commission should rely on such evidence and make your recommendations accordingly.
All right.
That will be all.
If they don't come, we can still make our recommendations.
Yes, my lord, whichever
if
way.
they don't come. See?
It will not look neat, my lord, for us to start issuing bench warrants on our former heads of state. That is my strong opinion, my lord.
Why? No, please. Why?
My lord, because of the offices which they occupied. So if...
Oh, no.
I'm coming. I'm entitled to my opinion, my lord. If by virtue of the offices which they occupied, and the evidence is not
Suppose I help you.
And the evidence
Suppose
is not...
I help you.
Yes. If the evidence is not personal to them...
I'm going to help you. Consider this situation. We are on a process of reconciling people.
Yes, my lord.
Would bench warrant aid reconciliation?
I don't think it will assist any reconciliation.
Do you reconcile?
If you compel somebody
to reconcile
come here and reconcile under duress, to my mind, my lord, that is not a reconciliation flowing freely out of the mind of a person who has been brought here forcefully, who has been compelled to appear here.
How do we get them to come voluntarily?
My lord, if they cannot come, like I've said, you can still make your recommendation.
I see. Thank you.
In the circumstance.
I see. Thank you. Any other SAN?
Well, my lord, I've not replied them yet.
No.
All of them to
when they finish, then we'll reply.
I reply. All right, so it's okay. Have you have it?
With greatest respect, my lord, I had occasion to comment that this honorable commission is walking into a new frontier. You are operating under...
Let's get one thing straight first.
Yes, my lord.
The exemption that will apply to the former heads of state will not apply to your client.
No, my lord.
I see.
The situation, my lord, is you have a judicial commission of inquiry set up under that enactment to carry out quasi-judicial responsibilities, carry out investigative responsibilities. At the same time, even though not mentioned, it suggests reconciliation in a psyche and context in which we are all conditioned to being adversarial. In the circumstances, my lord, you have become what they call, well, you have responsibility without power, the prerogative of the eunuchs throughout the ages. You have the responsibility, the power is not there. So I would call on your lordship that the first thing you ought to ask yourselves are, what are you here for? And what is the matter before you? What happened over the period between the time the event took place to the time you were seized with it? What are your functions and how do you discharge those functions? My Lord, in the discharge of those functions, unfortunately, we have to get mired into the law. The world can construct the law according to its wits, but you must construe it according to the law. The ground norm is the Constitution of Nigeria. It is downloaded into the normal legislations, and it soft lands into this kind of commission, which is carrying out a function for the first time ever and unknown, into the unknown, to reconcile people, and yet it has no time to even reorient our minds to forget about adversarial system for a while. With that problem, my Lord, the ground norm, if you go to the Constitution, which is the primary law, and repeating section 36 about fair hearing, you would need to relate, my Lord, to what is before you. Like I say, what happened? In the case of my clients, an event took place 15 years ago. Over the years, certain members of certain constituted institutions did certain things, properly, improperly, or otherwise. You will have little choice but to evaluate the historical events that transpired, because you, while occupying a quasi-judicial responsibility, at the same time, you are not duplicating, but being a continuum. So if there was a Nigeria police force which carried out certain investigations, the historical parameters have to be looked at from where you take off in the course of your proceedings and your recommendations, my Lord. And Section 36, which requires fair hearing, requires you also to look at the peculiarity of what's before you at the material time. In so doing, for example, we have an application which was subsumed by my learned senior as to the request that you dispense with the need for his client to appear before this honorable court. That was based on antecedents before this commission was set up, the actions taken by a constituted authority by certain persons alive and records which are there, and thereafter, after you came into being, the events that took place in the last 1 year, let's say from December to now, would have to be taken into account to determine whether a particular, the exercise of your discretion, which should be judicially and judiciously exercised, should be so done in the context of the particular person. For example, I would not like to take my learned senior for the 30th arrest for contempt. The learned reverend gentleman advised against it. It has happened. So there is a little bending backwards. In the circumstance, there is a little that one can do, but to look at the circumstances as to why you should dispense with certain appearances. In a normal court of law, you have options, my Lord.
Now, suppose
interrogatories.
Suppose we put it this way. Have you got the Constitution?
I have, my Lord.
Read Section 36.
My Lord, Section 36, subsection 1. It's already been read by the other. In the determination of his civil rights and obligations.
In the determination
of his civil rights and obligations. Yes, my Lord. including any question or determination by or against any government or authority. A person shall be entitled to a fair hearing within a reasonable time.
Stop.
Yes, sir.
Where does this apply?
Now,
in the determination of his civil rights and obligations, when there's an infringement of your right, you sue.
that is the new frontier, my lord, because you are going to make
right?
certain recommendations. Sorry,
No,
okay,
you may
sorry,
have
my lord.
exceptions, but am I right that when there is an infringement of your right, you have a list
Yes,
to
my
sue,
lord. Yes, my lord.
and you have parties
Yes, my
ad
lord.
litem?
Yes, my lord.
Is that the same thing here?
That is why I say you are in a new frontier halfway, sir.
I see.
In this context, a person called here with certain insinuations of one way or the other, which are accusative.
So
and with
you agree that ideally this will apply to adversary
to
proceedings,
adversary procedures.
but not solely, mainly, but not solely.
But you will be mindful of it in this case, my lord. You will be mindful of the fact of taking account of that provision, because a witness that's called here with certain grave insinuations is a little above a witness, because he is facing social conviction nationally, internationally, and within this hall. And he may be perpetually convicted socially, which is worse
Next
than
thing I'd like you
judicial.
to help us.
Yes, my lord.
Witnesses have rights.
I'm sorry, my lord.
Witnesses have rights.
Which?
Witnesses have rights. Yes. Parties also have rights.
Yes, my lord.
Are they the same?
In this case,
The rights of parties and the rights of witnesses, are they the same?
they are similar in your case, sir.
I see.
They are very similar because in the process of our experience in the last 1 year, your lordship was compelled to have to say nobody is being accused, nobody is under trial, but we would not heed. In that case, the level of a given witness in his circumstances indicates that he is just more than a witness if there are allegations against him. But if he was just called, please tell us.
Next area I
no,
want you to help us is many, if not all the cases cited deal
Yes, my
with actions in civil proceedings.
Yes,
I
my
don't
lord.
think any dealt with tribunal. So we've got
Ex-
to be a bit careful
Yes, my lord.
using them.
Indeed, my lord, we have to be careful in that, to a certain extent, my lord, because
If you agree with me there, we'll use them,
yes,
but
my
not to
lord.
be careful.
Yes, my lord, to a certain extent, in the sense that this judicial commission of investigation, the operative word is judicial, and therefore it was nascent and grew out and sprouted from the culture
Next
of
thing
the
I'd like you to
judiciary.
help us.
Yes,
Look
my
at
lord.
Section 18 of the Act.
Yes, my lord, the witnesses.
Any person,
Representation.
any person whose conduct or affairs are the subject of inquiry under this Act, that
Yes,
will
my lord.
relate to people who have petitioned.
Yes,
But
my
it
lord.
goes further than that. Or who is in any way implicated or concerned in the matter under inquiry. Leave the word implicated.
Yes, my lord.
Take the word concerned. Do you agree with me that all the heads of states are persons concerned with things in our terms of reference?
My lord, all the heads of states are concerned at certain levels of responsibility.
Good.
If the director of forestry in Jos went about cutting all the trees in Jos, and the head of state is here,
Now that you mentioned that,
the level is
our
not
term
his
of
own.
reference said, let them tell us whether this deliberate state policy or policy of any arm of government, or whether it was abused by state officials.
Yes, my lord.
So that is.
So in the circumstance, in that case, my lord, the head of state's concern will be part of your discretion to say, in these wide terms of reference,
Yes.
should we call A, B, C, D and say he is concerned simply because he read a thing on the newspaper during his dream under him?
That's why I said the word implicated. That will some tint of liability or
Yes, sir.
responsibility.
In
Just
that-
concerned, a person who has something to say about what happened.
My advice therefore, my lord, is for your lordship and honorable members to consider the various options which normally obtain in court of law. Should we send interrogatories in respect of A, because there are serious peculiarities in which his image, prestige, or security may be affected, or he is irrelevant? Or should we go to him and see him, or should we write him or invite him, depending on the nature of the matter and the relevance, and whether an interrogatory would suffice for
Have you
him
got
to
our
answer?
terms of reference?
Yes, my lord, I have
Now,
got it.
If you look at D,
My lord, I
Yes.
recommend measures which may be taken, whether judicial, which may end up in prosecution.
we were talking about not anybody accusing him of anything.
Yes, okay, my
Coming to
lord.
let us know what measures we may take.
Yes, sir. Recommend measures, whether judicial, administrative, legislative, or institutional, to redress the injustices of the past and prevent or forestall future violations or abuses of human rights.
Can they help us there?
They can in general terms.
They can.
In which case, my lord, they are not compulsible witnesses. They would be voluntary witnesses for that purpose. You are inviting them as good citizens to please be such good citizens in helping you constructively move onwards for the sake of the nation, just like you are inviting us here.
Yes.
It's exactly the same situation.
All
my
right, what
lord.
about C?
See, my lord.
Yes.
Determining whether such abuses or violations were the product of state policy or the policy of any of its organs or institutions, whether they arose from abuses by state officials of their office, or whether they were acts of any political organization, liberation movements, I think that was called out of South Africa,
Accusations aside.
or other groups.
Just leave accusations that
Yes,
they
my
did
lord.
this or did that.
In this case, my lord, you would call for that based on your own internal study of the history of the facts and who handled what, who did what.
Can we call them?
If at the end of your deliberations you do
We have
that,
deliberated.
having deliberated, then
And then we set summons after our deliberation.
you may issue summons, but you will have to operate the summons within the ambits of the law.
So you are asking us to
Within the law, my
hold
lord.
it. I agree
Yes,
with
my
you
lord. Yes, my
that
lord.
the general summonses issued were restricted to abuses by victims. We should issue a better summons.
No, sir. My lord, you should issue summons within the law. If my lord, if I refer my lord to section
Sorry,
6,
counsel.
I'm sorry.
Just one moment, because I'm in sympathy with what you're saying. I think that what is clear is that the fear of the witness box is the beginning of wisdom.
The
Now,
beginning of wisdom.
perhaps we can
Yes.
call it something else other than a witness box. And we can, rather than use the word summon, we can talk about a letter. Because I understand, from the point of view of what you are saying, and what,
Yes, sir.
what the chairman is saying,
Yes, sir.
I'm in sympathy with your position in the sense that if, and what the chairman read when we began the final phase of this sitting, I think it was section 3,
Yes.
made the reference to the fact that if a witness appeared,
Yes, sir.
the cross-examination or whatever is going to go on will have to be restricted to the subject of the petition.
The subject of the petition,
of the
yes,
petition,
sir.
yes.
Which,
And yes, so that if once you dispose of the issues
yes, sir.
from that petition,
Yes, sir.
it will be considered that that case is closed. Now, it seems to me that as long as somebody remains in that witness box,
Yes, sir.
if you then ask him whether he has any recommendations to make about
sir.
what should be done, the fear is that that evidence could be used against him. In which case,
It may be, yes.
yes, in which case the commission has, we've actually gone to great lengths to source for this kind of information, which
Exactly,
ties up
my
with
lord.
what I think Mr. Akpambo was saying.
Exactly, my
That
lord.
there are other ways. But my own feeling is that this is why I keep saying that for me, a lot of the issues are not about law. Even if these people came here
Yes, my
and
lord.
tried to explain to us
Yes, sir.
the issues you are explaining,
Yes.
namely, in governance, this is not how, it is not that one person just wakes up and does this, that, or the other.
Yes, sir.
Even if you appeared to say these kind of things, or to say what you can answer and what you cannot answer, what immunities and what limitations you have.
Yes, sir.
I think these are these are some of the issues, and that is why
Yes.
even when you say that it is not adversarial, we are literally in a trap. But the point still remains that the issues we're talking about are merely, as I said, I don't know, I don't want to emphasize the legal. It's just
Yes,
to
sir.
say that there is something symbolic in the issues that we are discussing. That even if the people came here and simply said to us, yes, this I can explain, this I cannot explain, this I want to answer, this I don't want to answer. Those are the kind of issues that we're
Yes,
talking
yes, my
about.
lord. These are issues that can be very pertinent, I agree, my lord, in that kind of class of matters. But in matters where the witness is concerned for certain very severe insinuations and the environment creates a problem, you would need to consider that in considering that his coming would be unfair, and therefore call on you to exercise your discretion subject to necessary exceptions, which means your judicious and judicial consideration of exceptions will include the fact that we are inviting this head of state, but we said in respect of A, B, C, D said against you, and the events of the past 12 months have not quietened his anxiety. Therefore, you should consider other alternatives for the purpose of calling them. My lord, I was going to go into the issue of the witnesses actually to limit myself to the area, having put these preliminaries. Because I want to go to the issue of what constitutes the appearance, my lord. Your initial questions.
I think we have got enough
Okay.
submission and appearance
Yes, my lord. But I have.
in the civil court and in tribunals.
Yes, my lord. But
The appearance by counsel, we've got
but
enough.
there's a general
All right.
general position. In law, a party can appear in person or by his counsel on his behalf.
A party.
Yes, in which case a person may be relatively a party depending on what he was addressed with in the summons. And the legal effect will be as if the party himself appeared in the absence of overriding legal position. Your Lordship in Adegoke Motors and Desanya actually went to Jewish dictionary and said, that's Adesanya 1989, 3 NWLR part 109 at page 272. In the primary sense of the word, the parties to a
Let's have the
proceeding,
reference. 19 what?
Adego Motors Limited versus Adesanya, 1989, 3
9.
NWLR, part 109. Your own maybe, Doctor.
Yes. What did he say?
Well, Oputa JSC, quoting Jewish Dictionary of Law 59 at page 132, said, in the primary sense of the word, the parties to a proceeding or application. This time, my lord, I want you also to discountenance my using parties by considering my witness as a bit
But
higher
are you
than
reading
parties.
yourself? Read.
The parties to a proceeding or application are said to appear on it when they are present in court, when it is heard. A party appears either in person or by his counsel or his solicitor. And In another authority, there was a statement that a plaintiff not present in court but is represented is as good as being present. Now, the other issue, my lord, which you asked, if it's been answered, is then I will skip it. Is an appearance by counsel sufficient enough to constitute an appearance?
In a civil case,
Yes, my lord.
not in a tribunal.
Not in a tribunal, but a judicial tribunal which is investigative, which is accusative mentality. One has to be cautious about those, my lord. But of course, in civil case. Wherefore said, it follows in my view that the third plaintiff is represented by a legal practitioner. It is as good as personal appearance, and the legal practitioners could be properly served with the pleading and other documents. Of course, I am warning myself that I am talking of a party in a civil court, but I am also advising myself that the mentality here is
Chief
that of
Ajay has drawn the difference between ordinary civil proceedings and tribunals. Do you agree with him?
judicial tribunals.
Yes. Do you agree with him?
In part, my lord.
You do?
There are differences in part.
Oh, I see.
And there are similarities in part.
Do you agree with Chief Ajay, his submission?
I
You've
do
got to
not
draw a distinction between parties to a civil case and witnesses in a commission of inquiry. Well,
No,
we have it down.
My lord,
Really,
that has been answered, but there is little, the difference depends on the personality and the issue and the circumstance. The issue now of, can a client cross-examine a witness when his client has not appeared? Now that, my lord, does not apply to my clients in that they have responded and they have filed an application as to the need to dispense with appearance of at least one of them. If I can go to section 192 of the Evidence Act, my lord, unfortunately, this is not the right place to canvass law totally. Any person, whether a party or not, that's Evidence Act. Section 192. Any person, whether a party or not, in a cause may be summoned to produce a document without being summoned to give evidence. And if he causes such document to be produced in court, that court may dispense with his personal attendance. If a party, therefore, produces documents which are sufficient, after you have exercised the discretion that you could call for it, since you cannot guarantee one or two things, especially, my lord, sometimes...
Aren't you putting the cart before the horse?
My lord.
One, can a stranger to proceedings introduce documents? A complete stranger?
He may apply for your leave to introduce documents.
He can, I cannot. Can a complete stranger to proceedings introduce?
He may.
He may.
Not can. Right. He may, if it is material relevant.
When do you become party to a proceeding?
When you are either a party ab initio or when you apply and you show that you have an interest.
When do you become party in quote to tribunal proceedings? I'm using party in quotes.
When you
they are not
told,
parties, they are witnesses.
When you are informed, come, your regime is accused of murder, therefore come and answer. Then it becomes relative. Everything, my lord, is relative. You are in a very terrible situation of waving through the forest to find your way.
Last question.
Yes, my lord.
Chief Apangwa did mention that a case is pending and this commission should have not been holding, although there's no order. Are you not in contempt by appearing?
My lord, I am...
Two of you?
No, my lord, in the...
You also in contempt.
In fact, I had to...
If the commission is in contempt and you're in contempt, where would you go from there?
So, my lord, that I had
all in contempt.
Yes, but I had... excluding the
Both
tribunal.
the bench and the bar.
Excluding yourselves, my lord. I had to advise myself that I looked at the order of the Federal High Court. I found you were stopped from inviting.
know why I ask this question?
Yes, sir, madam.
It shows we don't get much by empty legalism in an occasion like this.
I agree,
We have
my
to
lord.
do more than sticking to our guns if we really want to save this country.
Absolutely, my lord.
So,
I fully agree with that, my
it's a
lord.
beautiful legal, tussle legal exercise. I enjoy it as a lawyer, but as a Nigerian, I'm not enjoying it.
My lord, Mungo Park did not enjoy coming to Yauri and getting hit at the rocks. It's very tough getting into new
Any
frontiers.
other lawyer, we've got your submissions.
Okay,
Yes.
my lord.
Okay, sorry.
Where is Bill Federal? No. Let's hear them. This is the only.
With the greatest respect,
Yes. You want to speak as well? What do you say?
Yes, it doesn't.
Yes, my lord, may we make a submission now?
No, who is-
I'm sorry. Let me just.
Whom are you appearing for? For-
Reapo and Newswatch.
What are you submitting?
We are one of the petitioners.
Where they ask?
My own submission is very, very short. Just to agree with Chief Ganifaimi and Chief G.O.K. Ajayi that
counsel appear for an absent client in a tribunal of inquiry.
appear for an absent client, it's not possible.
It's not possible.
What we are saying is that once...
No. Issues before us.
Yes.
If he hasn't appeared, can his counsel appearing by proxy cross-examine witnesses?
No.
No. So you agree with Chief Ganifaimi?
Oh, yes.
All right,
definitely.
then. Any other thing to...
No, I just want to add that once the witness summons have been issued and served, the person served that fails to come to the commission the commission may commit the person for contempt.
No, we can't convict. We may recommend him to summary trial.
Commit for contempt.
We don't
because
convict.
That is what the law says.
Commit.
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 For contempt, because that is what the law says. Once the witness summons has been issued.
Read that. Read that again.
Yes.
Section what?
Yeah. My Lord, Section 10.
Yes.
Any person who, after service on him of a summons to attend as a witness or to produce a book, document, or any other thing, and notwithstanding any duty of secrecy, however imposed, fails or refuses or neglects to do so, or to answer any question put to him by or with the concurrence of the tribunal, shall be guilty of an offense and liable on summary conviction to a fine of 200 naira or to imprisonment for a term of 6 months. That is what the section says.
Summary trial by whom?
On summary conviction to a fine
Who
of...
will convict? This tribunal?
My Lord, this tribunal can
Will
commit him
convict.
for contempt. Yes,
I
my Lord.
see.
Yes, my Lord. If they fail to appear...
It's your submission. We've noted it.
I'm most obliged.
I
and
see.
they must be compelled to appear.
And then if
I'm most
it's a
obliged.
Summary conviction. Any other before we? Yes, sir. All right. My Lord, 3 questions. What constitutes appearance? Can counsel appear, or can a party appear by proxy not in a legal tussle in the High Court,
Yeah, my Lord,
but in a tribunal inquiry?
My Lord, you have a problem of interpretation of the Act itself.
Which Act?
The Tribunal of Inquiry Act, sir.
We've been interpreting it all the morning from 10 o'clock.
Yes, that is
Yes.
where the problem is.
That is number section 5, section 10, section
5C,
12.
if you read 5C,
Yes.
there's an exception there.
If you read Section 5C, it means it is not mandatory for all witnesses to appear. We've had that 4 times. Now, it's not new. If you read it in conjunction with 18, then your problem will be solved. And then on general questions, you are tasked. What is the result of reading it with 18?
It means that
you may be represented by counsel.
Yes, my lord.
What does that mean?
What it means,
having even in the normal court, you appear first.
My lord, you said you are not a normal court.
Yes. All right.
You have distinguished between a writ of summons in an ordinary court. All the cases have been cited, so you have not distinguished between a commission of inquiry and a civil court.
All
they
right.
are not all false. There should
All
be
right.
distinction.
What is the connection between 10 and 18?
10 and 18. 10 says you can punish if somebody doesn't come. But if you follow the exception in 5C that says subject to all just exception, if the person can justify he's not coming here, then he falls within that just exception.
When is that justification? He will stay in his house and justify.
No. His counsel can argue that a case, my lord.
I see.
Yes.
One justification this morning is that the Constitution.
Well, that is one example.
This morning.
The former head of state. Yes, those are the examples.
When in office or
I can also
after
say
3 generations.
I can say that the director of state security services can provide answers for you. That is another just justification. I
Thank
can
you.
also
Any
say.
other thing?
Thank you, my lord.
Any other thing?
Yes, my
No,
lord.
somebody is standing. I'd like to give the bar full facility. No. Chief, hold the moral armor. Keep your powder dry. Yes? Let this. They come tomorrow. This is a very.
My lord, I'm a Jan. My lord, the purpose of a
Number
subpoena-
one, can a
Yes.
party appear by proxy?
Yes.
Can a party in quote?
My lord.
Can a party appear by proxy?
Yes and no, my lord.
All right.
Yes.
We have written yes and
Yes.
no.
Yeah,
If
my
he
lord-
appears by proxy, can he cross-examine? Yes and no too.
No, my lord. My lord, the purpose of your subpoena is to get evidence. Even though this commission is not a court of law. But, my lord, in between, this commission has a duty not to endanger national security in the process of taking its evidence.
Are we taking evidence from people who are not even here?
My lord, I'm coming to that.
All right, since you're talking about that, you haven't read our mandate too. You haven't read the law.
No, within the issues
Have you
framed-
read the law? Have you?
That is why I'm standing up, my lord.
Have you read the law?
Very well, my lord. And I also know the issues that are being framed by your lordship for address. And your lordship wants assistance from counsel, and I'm prepared to offer
Have
one.
you read the law? I ask you. Open the law then. Section 10.
My lord, I don't.
Open the act. Section 10.
Thank you.
And read it. Any person who, after service on him of a summons to attend as a witness or produce a book,
I thought I would
document,
read it, my
or
lord.
any other thing, and notwithstanding any duty of secrecy, however imposed. What are you talking about?
If
no
my lord
matter
is,
what amount of secrecy
if my lord is
obliged to come.
if my lord is patient with me as my lord has been with the senior advocates,
Look,
my
we've
lord,
heard
I
about
may make
5
sense, my lord.
advocates.
Yes.
If you don't agree with them, write an opinion and give us. We'll look at it.
My lord, I won't be more than 2 minutes if my lord will be patient. I won't be more than 2 minutes. My lord,
Go on now, say what you want to say.
My lord, the 3 key witnesses that are being subpoenaed and who are not before the commission.
The question before the court is, number 1, can counsel appear for an absent witness?
He can, my lord.
2,
Yes.
if he does not appear, can counsel cross-examine?
He can, my lord.
Thank you very much.
Yes. Is my lord interested in being guided?
That's all we want, and you've answered the question.
Thank you.
No. What
My lord,
I've had senior advocates. You are not one yet. Let's. Yes? Last. What about the case on the list? Yes, what is your submission?
My Lord.
Are you one of us? Well, sit down. Now somebody standing. Yes?
My Lord, our...
Question. Can counsel appear by proxy for an absent witness?
The answer is no, my Lord.
No.
Yes, my Lord.
If the witness summoned under Section 5C does not appear, can counsel appearing for him cross-examine?
The answer is a resounding no, my Lord.
The answer is no. Thank you.
Yes, my Lord.
Now, do you want anything? I want reply to only one point. The point that the Constitution has a provision that we can't even issue the summons. Only on that point, and no other point.
Well, my Lord, I agree with your Lordship, sir, but I must clear a personal issue. My Lord has talked of contempt.
No, don't worry.
My Lord, it's very necessary, sir, because we are also talking to the world. I have not committed any contempt because, my Lord, this document...
I'm only interested in...
Yes, sir. Yes, sir. This document is Exhibit 3. It's Exhibit 3. So it is not contempt to exhibit an exhibit.
All right.
Secondly, this book, my Lord, is also Exhibit 2. And it shows how Brigadier was bombed to death. And therefore, this document, which is also an exhibit,
that will be addressed.
Can be so, my Lord, it's not right for my learned friend to say I've committed contempt by exhibiting what is an exhibit. Now, my Lord, the other issue I want to mention, he has said that Babangida was not directly mentioned. My Lord, if he looks at our petition, which I have here, your Lordship will look at paragraphs of the petition. That is Exhibit 1. My Lord, Exhibit 1 is so clear, and my learned friend unfortunately has not read it, with all respect to him. If you look at paragraph of that exhibit, which can be shown to my Lord, paragraph 6. Paragraph 6 states clearly names and addresses of persons who are directly involved. General Ibrahim Badamasi Babangida, President of the Federal Republic of Nigeria. Then, my Lord, if you look at paragraph I, that is 7I, it speaks of the evidence that will be adduced to show that Gloria Akon was a courier for the wife of Mrs. Babangida. So, no, please.
I'm only interested in one point.
Excuse me. No, my Lord, I'm sorry, sir.
Chief Gani Fayemi, I'm interested. Two of you can go on standing. It's all right. Don't worry.
My Lord, he is repeating the libel, and that is why it may not be fair to call these people to be handled the way they are. I'm sorry for having to interrupt, but I cannot.
I've asked you
finally,
to
sir, on this point.
Hold it. If the court tells you that you address on one point, it means they're satisfied on other points.
Much obliged.
Well, then address us on this question of we cannot even issue this summons.
Much obliged, sir.
That's a very radical one.
I have already addressed your Lordship, sir. But I will say, sir, relief sought to recommend for the prosecution of General Ibrahim Babangida for murder. So how else do we involve him? He is already involved.
I'm asking about his submission.
My Lord, the submission now on the constitutionality.
Yes, that's all.
It's unfortunate that my learned friend is not aware of the case of Gani Fayemi versus Inspector General of Police against Tinubu, reported in year 2000, 7 Nigerian Weekly Law Report, part 665. At page 481. I repeat, Fayemi versus Inspector General of Police, in re Tinubu's falsification, forgery. That's the governor of Lagos State. Number 7, Nigerian Weekly Law Report, part 665, page 481, where the Court of Appeal held that police, which is inferior to this tribunal, can investigate allegations of crimes committed by Mr. President, while in office, Vice President, while in office, Governor, while in office, Deputy Governor, while in office. If they can be investigated while in office, how can the fact-fighting tribunal?
I don't have a copy because we haven't got the library here.
Yes, I'll make a copy available.
If you can give us all the things quoted.
I will make 7 copies available.
Thank you. That's all we want.
So, my Lord, how can ex-president not be investigated? How can he not be
You have
available for
made your
investigation?
point. You have made your point.
Now, furthermore, my Lord.
Yes. How many days, when do we read this ruling?
Much of pleasure.
Today is what?
So, my Lord,
Monday.
It was easy to kill, but it's not easy
When do
to
we come
account.
for ruling? When do we come? No, we have another case tomorrow, is it? Counsel for the... I want all the cases involving these ex-heads of state addressed before we write a composite ruling. Is there anyone who have done Abdul Salam? We've done General Babangida. Another case is...
Abiola's case tomorrow.
Now, who is there?
It's
General...
Abdusalami Abubakar.
General...
Well, Abdusalami Abubakar, my lord. General
No.
Abdusalami.
What about the general who wrote us is traveling, he's coming back?
That's Buhari, General Buhari. He appears in Umaru Diko, Lily Gabare, and Owo.
Buhari, what about Buhari?
Buhari, my lord, yes.
His counsel is here.
He wrote to say he was traveling.
Buhari counsel, when is his case coming up?
Owo.
Because
on Wednesday, my lord.
We need to hear all so that we write one composite ruling.
Yes, my lord.
After hearing Buhari on Wednesday, then we can give ruling maybe Monday after Wednesday is what date?
My lord, Monday is 1st October. It's a public holiday.
4th October?
Yes, my first. Independence
3rd
Day.
October. Oh, first?
Independence Day, yes, my lord.
Can we sit on the 1st?
No, my
Answer
lord.
is no.
No.
So 2nd then? Why?
The 3rd, my lord.
For ruling?
Yes. Yeah, the 3rd is more convenient, my lord.
2nd October then, ruling.
My Lord, being a national day, I think we should...
my lord, I'm
People
sorry.
want to celebrate.
Yes, no, we
All
should.
right, to
It's
at
a
least
day of national loyalty. Not
All
to the
right.
government, not to this government that doesn't care for the people, but for
no.
for our nation.
Nobody's asking about that.
My lord, I'm sorry, my lord. My lord.
3rd.
The 2nd is a
3rd.
special hearing day.
3rd. Well, ruling adjourned to the 3rd. May I express my